Now, the bullying has reached a new level. The governor's labor cabinet is subpoenaing names of teachers who participated in a sickout to protest the siphoning off or diversion of funds from our public school system into private schools. They are threatening teachers with $1,000 fines, folks who are underpaid yet dip into their own pocket to help support their classrooms and our children's education. Enough is enough. Today, I'm sending a letter to the governor and the Labor Cabinet Secretary that demands that they withdraw these subpoenas. The letter tells the governor and the secretaries that the subpoenas are unlawful, and it gives them 10 days to rescind them. The letter goes into detail about how this exact situation happened in Detroit, how teachers there engaged in sickouts to protest structural problems with the education system, how their school system sued them, claiming they were engaged in an illegal strike or work stoppage, and how the teachers won that lawsuit because they were engaged in First Amendment speech. And at the end of the day, that school district that went after teachers had a legal bill of hundreds of thousands of dollars. The subpoenas here are not lawful, and that's because what the teachers were engaged in is protected First Amendment speech. They were not protesting their own work conditions. They were not protesting their own pay. Instead, they were protesting structural, financial, and overall issues in the education system, particularly the siphoning of public school funds in the form of tax credits to private schools. That is First Amendment speech that is protected by the Constitution. Second, the letter raises the key issue that the Labor Cabinet is not the employer here. The school districts are. And the school districts are not trying to take action. In fact, they canceled the entire school day. This is the Labor Cabinet trying to step in the place of a school district to go after teachers when the school district doesn't think they've done anything wrong. And that raises a serious and significant conflict. Why? Because the speech here was teachers' speech against our state government and what it was doing. And now that same state government is trying to step in front of the school districts to punish the teachers for the very speech against the state government. Last, this same section of labor law that is relied upon by the Labor Cabinet, that's been cited by this Commissioner of Education, makes it illegal and prohibits intimidation, threats, or coercion in labor relations. I have serious concerns that statements and actions of the governor, the Labor Cabinet, and the Commissioner of Education have or will reach the level where they are unlawful attempts at coercion, intimidation, or threats. In fact, we have already seen statements that threaten punishment, that threaten the exact action we are now seeing the Labor Cabinet take. Enough is enough. It is time to stop these petty attacks on our teachers, and I'm going to do everything I can to stop them. I'm willing to take a few questions. I know we've got just a short period of time.
Taking a step as an Attorney General to call a subpoena illegal is a very big step. Some people will say it's a political step in a year that you're running for governor. What do you say to those people?
I'd say take a look at the letter. It not only cites the law, but it talks about this exact case happening in Detroit, where the group in the position of the Labor Cabinet lost. But I tell you what, as Attorney General, you're supposed to stand up to state government when it tries to bully its citizens and bully its teachers. And that's exactly what I'm doing. I shouldn't have to do this. I could have never imagined a situation where a governor, a Labor Cabinet Secretary, and a Commissioner of Education repeatedly call names and attack our teachers. This should not be happening. It's time for it to stop.
So what action would Detroit be a federal law, or are you saying the Michigan law is similar to Kentucky?
Michigan law is similar to Kentucky law, and that prohibits strikes and work stoppages by public employees. And the court determined, because the speech was not about their work conditions, that it was not a strike or a work stoppage, but it was speech protected by the First Amendment.
So what action will you take if they don't rescind the subpoenas in 10 days?
I'll take them to court.
What evidence do you have, or do you have any, that the governor himself was behind these subpoenas?
Well, the governor has the power to certainly order the Labor Cabinet Secretary to rescind the subpoenas. And if the governor wants to claim he's not behind them, that he truly somehow didn't know and that he wants to do the right thing, he can order the Labor Cabinet Secretary to withdraw them. That'd be the right thing to do, and that's one of the things we asked for in our letter.
The General Assembly may have a special session coming up soon. Would you advise that the session be called during the school year, or avoid another sick-out situation and call it sometime after the school year?
Government is supposed to be of the people and by the people, and should always be conducted in a way to involve the people. Any changes in a pension system, any proposals, first they ought to come from a method where people who will be impacted have a seat at the table. Tom, you remember I commented on the legislative group that looked at pensions in this last session, and what I said is, why is it just legislators? They funded their own pensions. The people that need to be on that work group are teachers, police officers, firefighters, state workers, people whose own pensions are on the line, and they ought to have a role in forming any new plan, on commenting on it, and on questioning anybody who's going to come and present it. Certainly, if there's going to be a special session, that process should lead to it, and then it needs to be done at a time when not only teachers, but all other public servants who might be impacted have an opportunity to come to the Capitol.
Well, do you think it's a problem if teachers are calling in sick when they are not sick to come to Frankfurt and express their views? And if that's a problem, what level of government should take action?
We don't ever want schools to close. We want our schools to be open every day that they can. But what our teachers are faced with is a government that has lied to them, that has called them names, and that tried to trick them. Remember the pension bill, the sewer bill. When it was originally a transparent pension bill, there was no sick out at that point. The teachers came to the Capitol to protest, and that pension bill failed. So what did the legislature do? In the third to the last day, they took an 11-page sewer bill, turned it into a 291-page pension bill, and passed it through so fast that people couldn't even get up to Frankfurt to object. It is that type of action and betrayal that has led to a loss of faith by our education community, and I can understand why. And that's why we have seen the types of protests and calls that we have. But this type of speech from that Detroit case is protected free speech.
But is it a bad thing if a teacher calls in sick when he or she is not sick to do something else?
Well, if in this situation, as shown by that Detroit case, if they are coming to Frankfurt to protest bills like this private school tax credit bill, it's protected first speech under the Constitution.
You mentioned the Detroit case, but if you go to the Kentucky Supreme Court, you can't bring up the Detroit case as case law, can you?
It's persuasive. There's a difference between controlling and persuasive case law, but absolutely, the First Amendment is the First Amendment. You know, it's the United States First Amendment, and then we have clauses in the Kentucky Constitution. And I think every court looks at what other courts have done. And the fact that it talks about the real differences between what a strike and a work stoppage is. These teachers weren't up here because they were trying to get paid more. They weren't up here because they thought their work conditions in their schools were problematic. They were up here fighting for the very future of education, to keep funds from being siphoned off of the public education system and to go to private schools. What they were doing is protected First Amendment speech, and I support it.
You say they weren't here to get more, to get paid more, but the other side will argue that they were here to make sure that any cost of living stayed in any pension bill and anything.
That wasn't a part of any bill that was up in front of the legislature, so they'll have a hard time with that argument. Yes.
I apologize for being late, but could you just summarize
Yes.
your thoughts on the subpoena and what
Sure.
you're going to do?
The subpoenas issued by the Labor Cabinet are unlawful, and they are another attempt by this governor to bully our teachers, and I've had enough, and I think our teachers have had enough too. We sent a letter to the Labor Cabinet Secretary and to the governor today demanding that they rescind these subpoenas in the next 10 days. They are unlawful because the speech that was being engaged in by these teachers is protected by the First Amendment. These teachers weren't looking out for themselves or their work conditions. They were fighting for the future of public education and its funding. And as we've seen in a similar case in Detroit on sickouts, that speech is protected. The other problems is under labor law, you cannot engage in intimidation, threats, and coercion. And in between the governor, the commissioner of education, and the secretary of labor with these actions, their actions either have or are coming very close to crossing that line, which will make them further unlawful.
And again, what if the governor and the Labor Cabinet do not comply with your request?
Then we'll take them to court.
And again, I apologize, but this will be perceived as a political action because you are running for governor.
Well, all people have to do is look at that letter, is to look at the case law. But listen, I might be running for governor, but I still have a job as Attorney General. And my job is to stand up for people when they're being bullied, especially by their own state government. Look, we've had 2.5 years of name-calling of our public servants, of attacks on their pensions, and now trying to investigate and find people who aren't paid enough, $1,000 each. This is wrong, Lawrence. Whether or not I'm running for governor or not, I believe in right versus wrong, and I'm going to stand up against wrong.
In some of these communities, some of the parents were not happy with the teacher sickouts, especially parents
Right.
of students who were supposed to take the ACT in Jefferson County, and that got canceled. What do you say to those who say they'd like to know which teachers were out sick and that they have a right to know as parents?
Well, that's different than the Labor Cabinet trying to subpoena and fine them $1,000 apiece. I don't think there's any parent out there that wants their children's teachers fined $1,000. I get that it's difficult when school's canceled. I get that it's difficult to reschedule the ACT, but find a parent who thinks their teachers ought to be fined $1,000. I don't think you're going to find that, Chris.
Do you think parents have the right to know what the percentages of teachers were at their schools have left?
Well, I think certain information is public record, and I think certain information has been requested in other ways. But at the end of the day, this is about a subpoena that is a threat, that is intimidation, and that is not valid under the law. My job is to stand up to that subpoena and to ensure that either it is rescinded or we take action.
I just want to make sure I'm clear that do you think that if news organizations request information on how many teachers at schools were out there, they should be giving that information?
I'm the arbiter of open records. I can't give an opinion on open records before it comes in front of us, because if a school district doesn't give you information, you're going to come to us with an appeal. So as a part of my job, I can't do that proactively. All right? Thank you all very much. In this small room. Thank you.